This is Debra Pearlstein. I'm with Weil Gotshal Manges in New York, and I'm here today with my partner and my mentor, Irving Scher. Irv, thank you for being with us today to share some thoughts about antitrust law and your career.
Well, it's my pleasure.
Let's start with your background. Where did you grow up?
Well, I grew up in New York City in the borough of Queens.
Was that a blue-collar neighborhood, a middle-class neighborhood?
Well, the neighborhood I grew up in was quite blue-collar, much more than the rest of Queens. And I went to a high school that was filled with children of blue-collar workers, so not too many went off to college.
And what did your father do?
Well, my father was a route salesman for Kraft cheese. He would drive a truck filled with cheese to the grocery stores, get the orders, and deliver the cheese.
Did you ever go along with him?
Oh, once in a while my father took me with him. That's how I got introduced to the distribution of goods.
Very good. And were you a good student in high school?
I could have been, but I wasn't. The reason was I didn't pay much attention to what was going on during high school. I was much more interested in playing stickball in the streets of Queens.
I heard your major sport was hooky.
Yes, I was very good at hooky. In fact, that's probably how I got into college, because after playing hooky for 18 days in a row as a senior, they sent me to the school psychologist, who tested me in various ways and suggested that I apply to college.
And what did you do for college?
Well, since we couldn't afford for me to go out of town, I went to one of the city universities, now called CUNY, then called City College of New York.
And what did you major in college?
I majored, well, I started off in accounting, but I realized real quickly that that was not a good area for me, so I switched to something that I was more interested in, which was English literature, particularly the 19th century, which was pre-film.
Why did you think that English literature would be a good coursework for you?
Well, I always enjoyed reading. I was interested, I guess, at that time in becoming a teacher at some level, and English was my best subject, so that's where I went.
Okay, now you graduated, I believe, in 1955, and from there, where did you go?
Well, I was recruited by the Navy, actually, the so-called Office of Naval Officer Procurement, and they persuaded me to go to Officer Candidate School in Newport, Rhode Island, which is what I did, and I became an officer in September of 1955.
And how did you serve in the Navy?
Well, I went into the aviation branch, and the reason was I liked the extra $150 a month for flight time. But I didn't become a pilot. I became an airborne navigator and a so-called air controller.
Now, why did you choose the Navy over, I understand that was a draft at the time, why did you choose the Navy over other services?
Well, we'll start with the draft. I wanted to avoid that. And always having been a film buff, I thought the Navy was a more glamorous life than being in the Army.
And where did you serve while you were in the Navy?
I was attached to a squadron that was stationed in Guam, and we did two things. I guess we were very famous as being the so-called typhoon hunters. You've heard of the hurricane hunters? We hunted the typhoons and actually searched for the 75-mile-an-hour winds or greater. It was a little hectic. And also we were attached to Task Force 77 of the 7th Fleet, so we participated from the air in their mock wars. That's where I was an air controller of jet planes coming off the aircraft carrier. It was the early version of video games.
You were following them on a video screen?
Following them on a radar screen. It was actually before video games were invented, but maybe that's how they were invented.
Now, did you get involved in the law during your Navy career?
Well, you know, we don't fly all the time. We're on the land quite a bit also. I wasn't on an aircraft carrier. I was on a huge super constellation, which was land-based. So on Guam, I had to do something when we weren't flying, and I chose being the assistant legal officer. I couldn't be the legal officer because I wasn't a lawyer, so I worked for him. Even
as a non-lawyer, you could be the assistant, however.
Yes, and I represented defendants. I guess the Navy didn't care who represented defendants. Generally, it was seamen who were accused of being overly rowdy, not listening to orders, getting drunk and disorderly, and I defended them.
So how'd you do for your first clients?
Oh God, I don't remember the first client. I don't think my record was that great against the naval legal system.
But did that lead you to want to continue in a legal career?
Yes, that certainly got me interested in the law, and I applied to Columbia Law School figuring that was my best chance because Columbia at that time was linked to the Navy. They had the Naval ROTC at Columbia, and they were fond of naval people. I also learned they were fond of City College graduates.
So you got into law school and began in 1959?
1959 at Columbia Law School, and I really enjoyed those 3 years. I enjoyed the Navy too, but I really enjoyed the 3 years at Columbia.
Now, were you set on antitrust law from the first day of law school?
No, I didn't. I was really scared of all the Ivy Leaguers that were there at Columbia, and all I wanted to do was get by. But after I made law review the first year, I started looking at what I wanted to do, and I did an antitrust note that was assigned to me in second year, and then in the third year, I actually was asked to be an editor of an article written by Professor Milton Handler and one of his partners, Stanley Robinson.
Now, you had taken a class with Professor Handler?
In second year, I had taken his basic antitrust course.
He had one of the leading case books at the time.
Yes, he did.
And tell us, he's obviously a well-known name in the antitrust field. Tell us what it was like to be in a course taught by Professor Handler.
Well, of course, he was brilliant and took credit for all of the antitrust decisions written by Harlan Fiske Stone when he was his law clerk. But after that, he had many successes that we heard about. He was the senior partner in a what we would call a major antitrust firm at that time. I say we would call it because the size of a major firm at that time was always less than 100. And his practice was very important to him. And my main recollection is, as we approached the end of the class, Professor Handler would sort of slowly get to the door. When the class ended, he was gone downstairs to his driver, down to Midtown in his law firm.
Very good. So did you think about joining Professor Handler at his firm after you graduated?
Yes, I had the opportunity. I was interviewed first at school and then down there. And I was about to go back for my next interview when I met Ira Milstein.
And how did you come to meet Ira Milstein?
He was recruiting. In fact, I think it may have been the first year that Weil Gotshal was recruiting at the major law schools. So he put on a full court press. And he had been Milton Handler's assistant when he was at Columbia himself. And when he heard that I was interested in that firm, he said, "Why do you want to be in Milton Handler's shadow the rest of your life?" And that was telling.
And so how did he attract you to Weil Gotshal?
Well, he told me we have a large antitrust practice consisting of Ira Milstein, and I'd like to build the practice a little broader, and if you came, you could help me do that.
Now so you graduated Columbia and you joined Weil Gotshal 1962, and you've been at Weil Gotshal ever since.
Yes, I'm permanently attached to my chair.
There have been a few changes at a law firm since 1962, I can imagine.
Well, you being a partner at Weil Gotshal would be well aware. I was the 25th lawyer. We had 24, and including the antitrust department staffed by Ira. And today, one half a floor in Midtown Manhattan. Today we have about 10 floors in the General Motors building and 20 offices worldwide.
And the practice grew from Ira first and you to about 100 lawyers now?
We have 100 antitrusters, mainly in New York and D.C.
I gather there was one particular lawyer at Weil Gotshal during your career who made an impression, other than Ira.
Other than Ira?
Did you
my wife, who is my, yes, I met my wife at Weil Gotshal, and she's been my wife for going on to 25 years now.
Other than the firm growing, how about the law practice? Tell us about what you did when you first joined Weil in the 1960s.
Well, it was very heavily FTC-oriented. Our firm was unusual, or Ira was unusual, in being a New York practice with a very Washington, D.C., a New York antitrust practice with a very Washington, D.C.-like practice. And so I did a lot of FTC work, particularly those first 10 years, on both sides of the FTC, antitrust and what we now call consumer protection.
And on the antitrust side, your practice has always been distribution counseling, I gather, in litigation.
Yes, that's correct. Mainly distribution, because that's the area, other than mergers, that the FTC always has been very active in.
Why don't you tell us about one of your earlier cases, the Associated Merchandising Corp case?
Well, in the 60s, the FTC was very heavily involved in Robinson-Patman enforcement. That went into the early 70s. But in the 60s, I would say it was at least 30% of the FTC's business was Robinson-Patman. And we had a case called AMC, or Associated Merchandising Corporation, which I believe was the largest Robinson-Patman case they ever brought in. It had 13 department store respondents all over the country, large department stores, and a wholesale organization through which they purchased merchandise. We represented the wholesale merchandising, AMC Merchandising, the wholesale company, and local prominent lawyers represented each of the department stores, including lawyers who later became chair of the antitrust section.
So one of the nice things about the case was you met the antitrust bar all around the country?
I sure did. Just a few. I worked with Harvey Applebaum, who was at Covington working under Tommy Ostern, another luminary who was chair of the section earlier. Miles Kirkpatrick from Philadelphia, Alan Holmes and Dick Pogue from Cleveland, I think one or two others, but all of them became chair.
How did that case resolve itself?
Well, it was interesting. After 4 years of litigation, we actually reached a consent order with the staff, and that was sent up to the commission. And after about 6 months of wrangling among the commissioners, they couldn't reach a decision, and they dismissed the case but said, "We're going to watch you." They never went after us again.
Now, you mentioned some of these luminaries. Is that how you got involved with the antitrust section?
Yes, IRA was already involved in the section, and with some of those attorneys who were already involved in the section, they got him more interested, and he got me more interested in working in the section. I started, I would say, in '64.
What was your trajectory through the section?
Well, first I was what we call a Migley, writing and drafting and working in committees. Basically, the two I spent most of my time in, as you could expect, was the FTC committee and the Robinson-Patman Act committee.
And were you ultimately a committee chair?
I became chair of the Federal Trade Commission committee and was smart enough to make as my vice chairs Kaz Hobbs and Alan Silberman, who also became chair of the section.
And did you get involved in antitrust section publications?
Oh, yes. With Harvey Applebaum and Jim Loftus, two other
section
chairs, we were on the editorial board of the first Antitrust Law Developments volume in 1975, and that was a lot of fun.
And you ultimately rose through the section to become chair?
Took a while. 1988-89. When I said recently at one of the meetings I was chair in '88, '89, my partner Scott Martin responded, "Oh, a year before the Sherman Act was passed."
Now, I know this because when I was just a junior associate, you got me involved in the section. Do you think that's still a good thing for young lawyers to get involved in?
Well, you, as you know, was my assistant when I was chair, and when I left, I made sure I got you some kind of position, and you've, on your own, risen since. And that's the way to do it at the antitrust section. Volunteer to work on publications, work on programs, and that's, it's all on the merits. That's the way you get up there.
Do you still recommend that for young attorneys, that they get involved in the section?
Absolutely. It's a great way to network with your peers, meet people from law firms and companies all around the country, and really become a recognized and accepted antitruster.
Now, we've been talking about your FTC cases. You also worked on Department of Justice Antitrust Division cases even early on, did you not?
Yes. Well, we had one grand jury, which later became a major class action in the book industry, children's books. They called them library bindings, so they would last longer. And it was an industry where the wholesalers would sell to the schools and school districts and states, and the publishers started to compete with them, dual distribution. And questions arose actually in Congress leading to a grand jury and litigation that the publishers were dividing customers, not bidding on particular school districts. So when the cases started, it started at a very crucial time because in 1964, Rule 23 was amended, changed from an opt-in to an opt-out, and that started the class actions going. And with alleged bid rigging and customer division with governmental entities, you can imagine that cases started, and before long, the publishers were sued by, I think, all 50 states. Most of whom used outside counsel as their antitrusters. The case got multi-districted to a place that's become famous for multi-districts, Philadelphia, and we were assigned MDL 2.
So antitrust multi-district litigation was from the very beginning of the MDL process.
Absolutely.
Now, we've mentioned bookcases, retailers. You've been involved with some other industries consistently over your career, have you not?
Oh, yes, certainly the book industry, certainly the retail industry, the music industry, recorded music, electronics, magazine distribution.
How about airlines?
Well, apparel. Don't forget apparel and airlines. Yes, that's the unusual surface industry rather than goods industry that I have been involved in. I was involved with you in two major antitrust litigations in the early 90s. First, the so-called airline tariff publications case, which was the first electronics information exchange antitrust litigation, and resulted in cases by, we were sued in up to 100 private class actions that got MDL'd into Atlanta. We were sued by all 50 states for their own purchases, and the so-called Department of Justice of the U.S., the Antitrust Division.
Now you...
Wait, there was another one.
Oh, please.
The second one that we were both on in Galveston, Texas, was the predatory pricing case that was brought by Northwest, David Boies, and Continental, Joe Jamail, against American Airlines for predatory pricing, which went to the jury, and we got a jury verdict. I won't tell you why.
Now, you mentioned this odd outcome of the AMC case where the FTC, you had a consent order and then the FTC dropped the case. You told me you had another one that was had a similar result.
Yes, it was strange. In 1988, Terry Calvani, who was then chair of the FTC, decided to bring a Robinson-Patman case, which already had fallen into great disfavor by the mid-'70s. And it was a quantity discount schedule. He approved a complaint that was filed against 5 major publishers, and for allegedly discriminating through the quantity discount schedules in favor of the large retailers like Barnes & Noble. And we litigated that for a number of years, from 88 to 92. In 92, we reached a consent order with the staff. Went up to the commission, and the next thing that happened is the commission dismissed the complaint. So twice in my career at the FTC, I had reached consent orders with the staff only to find the cases thrown out, both Robinson-Patman cases.
And having very happy clients as a result.
Yes.
Over your 45-plus years of practice, Irv, I know you've observed some trends in both enforcement and the law. I wanted to talk about a few of those. One, you've alluded to it, is the change over time in the role of the state attorney generals. Can you talk about that a little bit?
Yeah, there were, I think, 3 events that resulted in the state AGs becoming major enforcers of the antitrust law. First, in 1976, the Hart-Scott-Rodino Act included, which a lot of people don't realize, the parens patriae provision, which was an interesting confluence of the private defense bar and the attorneys general, because previously in the Hawaii Supreme Court case, their parens patriae authority was narrowed considerably. So they were interested in getting more authority in the antitrust area to bring cases on behalf of their constituents. At the same time, the class action boom was really going on strong. This was before the Illinois BRIC 1977 decision on indirect customers. So the defense bar, major corporations were interested in doing something to get some protection from what they thought were cases that shouldn't have been brought, antitrust class actions. So this strange relationship started with the attorneys general, because the defense bar, and I was involved in this and sort of a predecessor to the Business Roundtable, we thought that it would be better if the state AGs brought these kinds of cases rather than the private plaintiffs bar. And the idea developed into the parens patriae portion of HSR, which allows the states to sue under the antitrust laws on behalf of their consumer citizens without having all of the requirements of Rule 23 involved, and they were given superiority over the private class actions. Essentially, if they settled the case with consumers, they would preempt the private suits. And that got enacted in 1976. So that was number one. The second thing would have been the lull in federal antitrust enforcement during the Reagan administration. The states formed in the early 80s, I believe. They may have had this before, but it became important in the early 80s. Within the National Association of Attorneys General, NAG, formed a multi-state antitrust task force led at the beginning by Lloyd Constantine.
From New York.
From New York. And they were concerned about the lack of enforcement, particularly against vertical restraints by the Reagan administration. Professor Baxter was big on horizontal cartels, but not on verticals, being a Chicago schooler, and the lack of merger enforcement. So the states saw a place for them to fill in what they considered a void, and they started bringing vertical, particularly resale price maintenance cases and merger cases in the mid-'80s. That was the second event. The third event, and I think it was 88 or 89, the ARC America decision in the Supreme Court, where the Supreme Court ruled that the state antitrust statutes pretty much could do what the states wanted to do, could go beyond the Sherman Act so long as you didn't have to violate the Sherman Act to be lawful under the state statute, the traditional preemption standard. And I think that all came together, and the states really have become a force in this area.
How did that affect the practice for those who were defending the companies that were being sued in these cases?
Well, now we had a tripartite concern in government in antitrust enforcement. We had the privates, which we always had. We had the antitrust division and FTC, the feds, and we had the state AGs. And as you know, the developments starting in the late 80s and continuing today is a major FTC or a DOJ antitrust case will immediately result in private class actions. And quite often, the states will have worked with the DOJ or FTC, or, and I've had this experience as well, once the word gets out that the FTC or DOJ sued, the states start investigating and may bring a suit.
And did this affect the settlement dynamic at all?
Very much so. We had to worry about criminal or civil penalties from the DOJ, FTC consent orders, and another aspect of the 70s was the FTC Improvement Act, which gave the FTC some restitution monetary powers. And we had to worry about class actions and settling with the states for their citizens, settling with the, if we settled and didn't litigate, settling with the privates in their class actions, worried about state civil penalties. We're litigating, and litigating on three fronts can be very costly for a client.
Did you find that when you settled with the states, it would have an effect on the private class action bar?
Well, as I said, the parens patriae statute gives the states superiority. And I've had that experience, particularly most recently, I would say, in the 9 West litigation, where private suits were instituted. The FTC was investigating at the same time, and we filed a motion to dismiss the private MDL, and negotiated a settlement in the while the motion was pending with the FTC and states. We reached a settlement with the FTC in the states for the consumers of the states, and the New York State AG, Linda Gargiulo, came into Judge Parker, who's now on the Second Circuit, and urged him to dismiss the private class actions because the Federal Trade Commission had settled and gotten restitution for the citizens of the states, and he dismissed.
And is that still true that you sometimes find the states preempting the privates, or do you find them now more working together?
I think today it's more unusual. I think my first experience was in the late 90s in the Toys R Us case, where for the first time after the FTC had won its case against Toys R Us, the company got sued in class actions. There were direct customers consumers were direct customers of Toys R Us and manufacturers that sold to them. So a number of class actions were instituted, and the states also got involved. And for the first time at our settlement negotiations, there were representatives of the states and the private plaintiffs' bar at the table.
Working together.
And they worked together, and we got a resolution, joint resolution of the state case and the private suit. Happened to me again early in this decade, in the compact disc minimum advertised price cases, where the FTC issued a consent order. We were sued by the states, we were sued by the privates. It was MDL'd into Maine, and we were litigating, but eventually settled. And again, state AG representatives and private plaintiffs were at the settlement table, and where we worked out a settlement both for the private suits and the state.
Where do you sit on this question of whether the state activity is helpful or not helpful on the enforcement side?
Well, I'm a proponent of state enforcement, particularly when it is felt by some sectors of the economy that the feds may not be enforcing the antitrust laws enthusiastically, and also for the reason that I would prefer generally to settle with the states rather than in private class actions. So I think that the states have a major role to play. And by the way, Jim Rill and I, when he was chair and I was chair-elect and then I became chair, brought Lloyd Constantine into our council. And since then, there's been a representative of the state AGs on the council continually.
Right. Now, we've talked about the states for a bit. One of the other trends I think you've observed in your career is a great deal of change at the FTC and its role within the federal system.
Well, in the 60s, when I started my activity with the FTC, I've mentioned that they focused on verticals, and in particular Robinson-Patman. And as you know, Robinson-Patman is not favored by most antitrusters and economists as being something that should be actually in existence. They've gone away from that. The last real Robinson-Patman case was that book case in 1988. In the 60s also, some of the so-called consumer protection cases didn't involve national advertising, but small companies, for example, that claimed they were made in the U.S., but they were made in China, things of that nature, leading to the Nixon appointment of a commission headed by Miles Kirkpatrick in 1969, I believe it was.
It's through the ABA, I believe.
Through the ABA. Miles was, I think he was chair. It may have been chair at that point. He was chair either 69 or 70. And Bob Pototsky was the reporter to the commission, and some antitrust luminaries, and they thought that the FTC needed total reorganization. So the next thing Nixon did was appoint Miles Kirkpatrick as chairman of the commission, and he brought in Bob Pototsky as one of his bureau directors, and the focus changed dramatically in the 70s.
What, they brought different kinds of cases?
Yeah, for example, I think I mentioned to you my famous hat case in the 60s, which involved the geographic origination of hats, straw hats. The hats were made in China, but they were called Milan hats, M-I-L-A-N, and the FTC said, get out of here. Those hats are being passed off as hats that were made in Milan, Italy. So throughout that litigation, we kept using the term Milan, and the FTC staff kept using the term Milan, and we lost, unfortunately.
You're saying this was the FTC's enforcement effort back in the 60s?
Right, and in the 70s, after Miles took over, they shifted their attention to national advertising. This is before the National Advertising Division of the Bureau of the Better Business Bureau came into being. And I think that that came into being because of the active enforcement at the FTC. I think that the industry wanted to show that it could police itself.
These consumer protection cases, whether they're hats or otherwise, always seem like they're a lot of fun. Do you have a good recollection of a case that was particularly fun with the FTC involving consumer protection?
Well, you know, I've always been a fan of Bob Pototsky, and I think he's a great lawyer. And I've known him since 1969 and the Kirkpatrick Commission. When he was bureau director, he brought a case involving a product called Black Flag insecticide, and supposedly it killed the home bugs. And the complaint alleged that there was a new strain called German cockroaches that weren't killed by Black Flag. So we wanted to prove to Bob that the product worked. So we brought in a nice jar of German cockroaches, poured them on the table, and showed that the Black Flag killed them.
Did it kill them?
It killed them, but he took the position that they were already dying.
And did you bring the case?
We entered into a consent order.
Another one that we still laugh at around the office is not an FTC case, but a private case involving two gentlemen who had probably less than their 15 minutes of fame, Milli and
Milli Vanilli. No, there was Rob and Fab. They were Milli Vanilli. They were great dancers and very good-looking guys, but they didn't sing. They lip-synced to their songs, and their records shot to #1 were very, very popular, and the word got out. It leaked that Rob and Fab were not singing, and class actions started all over the country, brought by dissatisfied consumers, including a couple of cases in federal court. We got the class certification motions dismissed, actually, and settled the case for not too much money in Chicago, Cook County.
So let's think back a little more globally over the last 45 years. I think you would say this is a period characterized by great change in the antitrust law.
Absolutely.
Which changes stand out to you?
Well, unfortunately for the plaintiffs' bar, I think they're all the crucial decisions of the last half of the 20th century were pro-defendant. Starting with GTE Sylvania and the bringing in of economics into the Supreme Court, and the statement that the antitrust law should focus on interbrand rather than intra-brand competition. That was a major decision. Matsushita, of course, in changing the evidentiary standard for conspiracy favorably for defendants. Of course, Legion, which was the natural follow-up to GTE Sylvania, and Trinco. I think that Trinco has really protected monopolists. Justice Scalia, who in the Kodak case said, we look at monopolists through a special lens, in the Trinco case seemed to laud monopolists for all the wonderful things they do. And I think that Trinco is going to lead to a major trend that's going to make it very difficult for plaintiffs to win cases against monopolists.
It doesn't sound like you necessarily think change is good in this case.
Well, particularly in the Section 2 area, the dominant company area. I'm certainly in favor of the concept of interbrand competition being the focus of the antitrust laws, and the Robinson-Patman Act not being a major antitrust enforcement device, and vertical restraints generally being lawful. But I think once you have a defendant with market power, or in particular monopoly power, I think the law should be more plaintiffs-oriented than it seems to be at this moment.
Well, Irv, I know I enjoy seeing you in the office all the time, but I also know you have the opportunity to go and play golf and spend time with your family. So tell us, after 45, 46 years of practicing antitrust law, what is it that gets you up every day and ready to do it again?
Well, I love antitrust even more than John Grisham, and I like teaching it. As you know, I'm an adjunct professor at NYU Law School teaching an antitrust course. I've always been considered a mentor at the firm and a teacher at the firm. I was chair of the PLI Annual Antitrust Institute for about 30 years. So I've loved learning. I've loved the law side of antitrust, learning it and teaching it. And as I've said to you, it's also my hobby. I've got others, but it's a major hobby of mine.
Well, thank you. Thank you for giving us the benefit of your thoughts, and thank you for being a partner and a mentor for all these years.
It's been my pleasure. How do we do?